Hello everyone, I'm Sally Kinney and welcome to the second half of Season 2 of Deconstructing Rape, the podcast for academics, survivors, and activists seeking to understand and mobilize to prevent sexual violence. In Season 1, I spoke with survivor scholars about their experiences of sexual violence and their research findings. In Season 2, I talked with scholar activists about public policies to hold perpetrators of sexual violence accountable, erode rape culture, prevent sexual violence, and help survivors heal. Each episode contains sexually explicit content and adult language. Use discretion when listening. Deborah Tuerkheimer received her AB from Harvard and her JD from Yale. She clerked for Justice J. Rabinowitz of the Alaska Supreme Court and served as an assistant district attorney for the New York County District Attorney's Office. She was a law professor at the universities of Maine and DePaul until she joined the faculty of the Northwestern University Pritzker School of Law, where she is currently the class of 1967 James B. Haddad Professor of Law. When I began teaching, researching, and advocating about sexual violence in 2011, I reached out to my friend and colleague Martha Chamalis, a feminist legal theorist and expert in torts, employment discrimination, and sexual violence, whom I interviewed already for this podcast, about who I should read, knowing little about the criminal law beyond Susan Estrich, Catherine McKinnon, and Stephen Schulhofer. She immediately pronounced Deborah Tuerkheimer, and I read and taught her 2014 article, Slutwalking in the Shadow of Law, published in the Minnesota Law Review. Tuerkheimer consolidated her arguments in her 2021 book, Credible, Why We Doubt Accusers and Protect Abusers, which I also taught, coining a number of helpful terms heretofore captured under the broad and perhaps sometimes unhelpful concepts of rape culture or rape myths. For those of us who wore buttons proclaiming, "I believe Anita," Tuerkheimer's term, the credibility complex, helped explain what had changed and not changed between the testimony of Hill and Christine Blasey Ford. Tuerkheimer argues that credibility has three components: it happened, it was wrong, and it matters. While almost everyone believed Christine Blasey Ford, a majority of senators did not conclude Brett Kavanaugh harmed her enough to jettison his ascension to the Supreme Court. University of Pennsylvania law professor and co-host of the podcast Strict Scrutiny, Kate Shaw, interviewed Tuerkheimer in 2022 after her publication of Credible, and I will do my best not to duplicate that informative discussion, but link to that episode in the show notes. Tuerkheimer is also an elected member and advisor of the American Institute's project, Sexual and Gender-Based Misconduct on Campus, and for the Model Penal Code's Committee on Sexual Assault and Related Offenses. The American Law Institute, an organization of 3,000 lawyers and judges, first drafted the Model Penal Code in 1962 after 10 years of work to modernize, standardize, and consolidate criminal law, replacing the inconsistent common law. It guides legislators in reforming law and judges in applying the law and in sentencing as a consensus on best legal practices. The 1962 Model Penal Code was both a catalyst for and result of feminist efforts to reform rape law. In 2022, the ALI revised the code, attempting to incorporate a more modern standard of sexual behavior and consent without making the code too punitive, but rejected an affirmative consent definition. Tuerkheimer has written extensively about rape exceptions to abortion restrictions, rape trauma syndrome, the #MeToo movement, and informal mechanisms for holding perpetrators accountable, and has been a powerful voice in the popular media in op-eds. But rather than exhaust all my limited time summarizing her important work, let me now speak with her directly. Right at the beginning of Credible, you tackle the difficult theoretical question of the mutually constitutive nature of law and culture. You've dedicated your career to documenting and trying to change damaging components of criminal law that instantiate the credibility complex, from the requirement of resistance to the utmost, to jury instructions, to the corroboration requirement, to the demands victims report immediately. Yet while we have seen rape law reform, albeit incomplete, we witness and you document what Reva Siegel labels preservation through transformation. 50 years of rape law reforms have done little to move the needle on holding perpetrators accountable. Yet I believe you, like I, believe that law has a powerful role to shape cultural attitudes at the same time that justice can also help survivors to heal. So how do you reconcile these two things?
Well, thank you so much for this conversation. It really is an honor to speak with you. For me, the question of credibility really runs between the substantive law and cultural transformation. It kind of connects the two. And if I were to take a step back and think about the trajectory of my own work, I would say that much of my writing, particularly toward the beginning of my career as an academic, focused on the importance of substantive law change and law reform. And I continue to believe that that is part of the project of moving us toward a more just society, a society in which gender equality is more closely realized. But the fact is, these laws on the books, no matter how much they reflect the realities of sexual violation, those laws are applied by people. And if the people who are in positions to apply or not apply the law, to enforce or not enforce the law, are choosing not to do so, then the laws are of very little utility to the people they're designed to protect. So while I continue, again, to believe that we ought to have laws that are reflective of the experiences of survivors, I also think that we must attend to questions of credibility that lurk underneath all questions of law and law enforcement. And that is what brought me to thinking about the credibility discount and the credibility complex and all of the ways in which our own biases and blind spots interfere with the application and enforcement of the laws on the books.
Right, thank you. So you've also been a powerful leader, in addition to critiquing the criminal law, of advocating for a theory of sexual agency that reaches beyond the criminal law to make visible the harms of unwanted sex. Can you talk a little bit about how you're thinking about these public conversations and perhaps the informal callings out? How should that exist within our priority for trying to change the criminal law?
So I am concerned about what I call rape myopia, which is that the definition of rape in the criminal law, which is exceedingly narrow and rightly so, right? The criminal law punishes the most serious infractions, the most severe violations, the violations that are worthy of our collective moral condemnation and hefty punishment, all of those things. But there is a range of sexual violation that exists outside of that very narrow definition of rape. And attending to rape should not obscure that sexual violation is harmful, even to the extent it doesn't rise to the level of criminal rape. I think that the Me Too movement put on copious display that sexual violation falls on a spectrum. There is a continuum of sexually violative behavior that, again, is harmful to victims, to survivors. And we make a mistake if we disregard, dismiss, overlook that sexual violation simply because it can't be proven in a criminal court as violative of our rape laws. If we're to pull back even more, we can think about the structures that are in place that allow this full range of sexual violation to continue. It endures because we as a society, we as a collective, allow it to endure. We look the other way. And I think that kind of complicity is also part of what the Me Too movement was aimed at surfacing. And we're seeing maybe a next iteration of that surfacing as these Epstein files have been released. And we see the ways in which power protects male sexual entitlement and male prerogative, and it normalizes this range of violation. It's true that Jeffrey Epstein committed crimes, right? And he ultimately was prosecuted. It took a long time for that to happen. But what about the cast of characters that supported and enabled that kind of abuse, falling short of criminal violation, but still, I would argue, worthy of our attention and our care?
It's that all the Epstein stuff is so triggering, and it seems so strange. Just from watching it, it seems like people are being held accountable outside of the United States much more effectively than they are within the United States so far, or at least that's what it seems like to me with the arrest of formerly Prince Andrew. I also have been listening to a podcast called Blooming After Grooming about two young women who were sexually abused by their high school teacher, and they really are examples, which you talk about too in your work, of the way victims use these sort of heinous criminal law standards to discount the harm. I've heard, said, but were you raped? Like if but for that, you haven't been harmed. But then even, of course, rape victims say, well, I wasn't beat up, or I wasn't this, or I wasn't that. And it seems like it's very hard for survivors to articulate the harm in a spectrum. If there's a harm that's on a more severe part of the spectrum as well, to recognize this other thing as really harmful and damaging as well. And it's so hard for people to make sense of.
Yes, and your point is so well taken that even within the category of criminal rape, the kind that happens with lots of physical force that causes injury, right? That is often seen as different in such a way as to minimize the harm of what's not that kind of violent rape that leaves physical injury. So there is this almost gravitational pull to try to differentiate between what really matters and then everything else. And I want to suggest that sexual violation matters regardless of where it falls on the spectrum, which is not to say that we collapse the spectrum and we don't make distinctions, because sometimes those distinctions are important. But the harm of sexual violation matters regardless of whether the infraction is the most serious kind of infraction, or something that's somewhat less serious, or something that feels very commonplace. I think that part of what the Me Too conversation revealed is that some of these types of sexual violation are ubiquitous. They're so normalized that until people started talking and telling their stories of harm, it could almost be ignored. It could almost be pretended away. It could almost be as if it weren't going on every day. And, this raises really hard questions about sexual norms and gender relations, things that make us really uncomfortable. There's a reason why we don't like to talk about this.
And I don't feel like we've made a lot of progress. I mean, I was just thinking as you were saying this, I was thinking, oh dear, that's what Catherine McKinnon got in so much trouble for back in the 80s for Signs, because she said, how do we make sense of the criminal law of coerced sex when there's a lot of coercion in so-called normal sex? And that, of course, got interpreted as all heterosexual sex is rape, which is not what she was trying to say at all. But I am troubled by, first, it's, as you point out, it's exactly the inverse in terms of what survivors say about the harm, is the betrayal trauma from institutions and intimates for sexual coercion is much psychologically more damaging for women sexually assaulted by members of their combat unit, by their partner in the police force, by their intimate partner, by their next door neighbor, because they're so much more destabilized about their own sense of who they can trust, and that the harm of a loved one, an acquaintance, violating you as opposed to the stranger that we've all been warned about, that we're supposed to know about, is more profound. But yet it's always thought about as exactly the inverse in terms of the significance of the harm.
That's right. There's something that is sort of both paradoxical and perverse about the persistence of the stranger rape paradigm. right?
Well, that's what I wanted to ask about you next, because you talked about that in your Illinois Law Review piece in Victim Reconstructed. And you talk about, and I think this is we see this in battered women who kill and other things, this idea of an ideal victim, whether it's a sexual harassment victim is, somebody who never swears at work or tells a dirty joke or wears, provocative clothes or whatever, like she has to be the perfect victim and all that. We see this ideal victim a lot in law. So we're told, oh, well, and I just think so much of rape law is overdetermined because we sort of say, oh, well, the law can't conceptualize acquaintance rape and intimate partner rape because it thinks about stranger rape. But of course, the law doesn't deal with stranger rape well either. I mean, we see in these cases of the rape kits, which were kind of classic stranger rape, and those aren't prosecuted either. So how do you think about this issue about, I feel like we do want those 10% of rapes, those serial rapes, those stranger rapes, to be prosecuted too, but we don't want to instantiate this idea of the stranger rapist and downplay the others and just reinforce that dichotomy.
Yeah, I mean, it's such a rich question. Maybe I'll break it apart a little bit and start by talking about the ideal victim, because I think that that's so central to the point that you made and the point that I try to make in my writing. So the perfect victim can maintains a hold on our popular imagination, and I really insist upon that because I feel that often when I talk about this, people want to kind of wave a hand and suggest that this is a thing of the past, and it really isn't. I mean, I can talk about cases that have come up in the last month where this perfect victim is very much in play. So the perfect victim behaves in certain ways before, during, and after the assault. And so before, and you kind of mentioned this, there are certain ways in which she would dress or not dress. She wouldn't drink alcohol to excess. She wouldn't use drugs. She wouldn't have certain occupations. She wouldn't have certain sexual histories. So there are all sorts of expectations that we have of victims that relate to things that happened before the incident. And then during the incident, the perfect victim fights back physically really, really hard. And this is related to that stranger rape paradigm that we mentioned a few minutes ago. So the idea is that if you were attacked by a stranger in an alley with a knife, your instinct would be, so goes the mythology, to fight back and to do everything you can to scream and to fight back the attacker. And so when someone doesn't do this, right, she's deviating from the perfect victim script. And then afterwards, of course, there would be no further contact because you wouldn't have contact with a stranger. So anything that happens between the victim, the survivor, and the assailant, or the abuser after the incident is held against the victim. If she doesn't report right away, that's held against her. And so in all of these ways, I think the ideal victim, the perfect victim, persists, endures. And I want to be clear that this works to the detriment of real victims, because to the extent the behaviors depart from the behaviors that the so-called perfect victim would exhibit, the real victim is seen as less credible. She's seen as less likely to be reporting what really happened. She's more likely to be blamed, and she's more likely to be dismissed. Her harm is likely to be disregarded, and she's not likely to receive our care. So that's what I'll say about the perfect victim. Now, I'm stressing that the vast majority of sexual assaults, and this is something that you've said too, those are perpetrated by acquaintances. Those are perpetrated by loved ones, by spouses, by boyfriends, by bosses, by coaches. It goes on and on and on. The kind of stranger rape paradigm is in reality the exception. So what do we make of these shelved rape kits, right? What do we make of the fact that across the country there has been this backlog of rape kits. They've not been tested and they just sit. And only recently in some jurisdictions have we started to address this problem, and there's sort of been a spotlight shined on it. Well, it turns out that those kits have been shelved because the case was never pursued as an investigation. So they're a symptom of a larger problem, which is that law enforcement officers tend to short circuit investigations into sexual assault allegations. When someone comes in, even if there's a rape kit, and even if there's no question about the identity of the perpetrator, I should say, there's often a rape kit because that's part of the process. If you decide to report soon after the incident, soon enough after the incident, that there's physical evidence that may be obtained, there's going to be a rape kit. But law enforcement officers often decide early on that this is not a case worth pursuing. And so those rape kits just sit because the case has been closed. It's been resolved before the law enforcement officers did what their job is to do, which is to try to gather evidence and figure out if there's enough to pursue a case. That's not what tends to happen here. There's case attrition that is remarkable, meaning that the case drops out of the system before it ever gets to a jury. It is only the very rare case involving sexual assault that makes its way all the way to a courtroom, despite the fact that we see movies and TV shows that suggest otherwise. So these shelved rape kits, when they are examined, it turns out that a pretty high percentage involve serial offenders. And depending on the jurisdiction, 1/3, even up to 50% or so of these cases involve serial offenders. So there are lots of reasons to be disturbed by the fact that that law enforcement officers are not pursuing cases when they come in the door, and they're not pursuing an investigation. And we can talk some about why that happens. The short answer is credibility discounting, yeah. But these shelved rape kits are also emblematic of a large problem, including that many offenders go on to do it again, whether they're assaulting strangers or acquaintances.
Or both.
Or both. Absolutely.
It's so discouraging because I feel like there's been so much energy thrown at this problem from, exposés and people who've, done all those studies, some of the people we've talked to on this program, the training that groups like In Violence Against Women International and Equitas, the one you mentioned named by Senator Klobuchar after the Minnesota case, all the Violence Against Women Act stuff. And it seems like this sort of training in police and trauma-informed interviewing and investigation and stuff. Do you see? Sometimes I feel like I just want to throw up my hands and say, abolish the police, and I'm not, but I do really believe that criminal law remedies are one piece of the puzzle. And if we sort of give up and say we're not going to have any penalty for these harms, that we're ceding too much. So where do you fall on this?
Yeah, I have a piece that's forthcoming. It's called Survivor's Justice. And it takes seriously the notion that a just legal system enables survivors to make a choice about what they want to do. And so for some, that means pursuing a criminal law sanction. And it's really important to have the collective moral condemnation for many survivors, but not all. Some survivors are more interested in pursuing a civil remedy. Some are interested in alternative processes like restorative justice. Some want nothing to do with any of it. And so for me, I think the sort of right approach is to say, let's improve all of our systems so that they're fair, so that there isn't credibility discounting at that initial stage, so that the legal processes that are available to other kinds of victims and survivors are also available to those who've experienced gender-based violence, and in particular, we're talking here about sexual assault. And I don't think it's my role to make a decision about which system is better than any other. I think we really truly, well, survivors really truly deserve to have systems that are going to fairly adjudicate their allegations. And that's not the system that we have right now. Obviously, we're far from that. I want to make our systems better, all of them.
Well, I think that's what may be a uniquely important contribution of your pieces about informal reporting, because you put it squarely in the context of the failures of the criminal law of Title IX and Title VII, and that people they don't have a meaningful choice because those choices are excluded. And that's one of the things that worries me about one of the programs that you have, sort of like Callisto, and I saw this happening at Tulane, where it was the justification for the mandatory reporting, which I'm actually against, is to say, well, we want to make sure we get everybody in the system so we can identify serial predators, and we want to get people access to help. But there's a flip side of that too, which is the failure of the Title IX procedures and the criminal law procedures in New Orleans, and that those are utterly useless in holding perpetrators accountable. And so it's sort of like, oh, well, you don't want to go through this, and it's just a disaster. So you can have all these other services, and then you won't suffer more harm. But, I like the way that in your pieces you sort of really put, right front and center, these things result from the failure of these other accountability mechanisms, and everyone knows they're a failure. And no one uses them. So when people say, why didn't you report? That is just about the dumbest question there is. The really dumb question is, why would anybody report?
Yeah.
And you do that with sexual harassment, campus stuff, and that. Well, don't want to be total Debbie Downer here. So one of the few bright spots on the horizon, I think, was really interesting in one of the pieces that you wrote about the role of expert witnesses. And I was really interested in what you had to say about this, because you use that as an opportunity for rightly criticizing rape trauma syndrome. And so it seems like the experts, in the way that you talk about, really could be helpful for jurors and possibly judges in overcoming this credibility discount by saying, this is people freeze, they have contact. You could explain what actual survivors do. It's interesting, though, that there was an earlier piece by a woman I admire very much and who's been on the program, and her student, Laura Gray Rosendale, who wrote a great book called College Girl about her own rape and prosecution of the rapist when she was in college. And they talk about how they had kind of criticized what was going on, in the talk shows in the 90s, that the women survivors and some male survivors, they were kind of teeing up the horrible experience. And then the experts were brought in to say, here's how to make sense of it. And I really wrestle with that, what we now call kind of that hermeneutic injustice, or that epistemic injustice of that. But at the same time, what we were just talking about before, and when you were talking about the ideal victim, the other thing about the ideal victim, of course, is that those standards are internalized by survivors who shame themselves for not fighting harder, screaming, doing things that hurt their case or whatever, and they blame themselves. So can you talk a little bit about kind of your thoughts on, how that having the expert is kind of a workaround, but also kind of then reinforces the idea that victims can't articulate it effectively themselves without this added boost in the courtroom or on the talk show?
Yeah. I think that there are some real tensions here that, as you point out, I am drawn to the idea of expert testimony that is not pathologizing. And so that's why I think the move away from quote unquote rape trauma syndrome to expert testimony on the effects of sexual assault and the behaviors of survivors, plural, right? All sorts of different ways of responding. I think that what's important about that is that juries, and I'm now thinking about courtroom testimony by expert witnesses, juries often need to be educated. So this is a way of correcting for the discounting that might otherwise happen because of these continuing misconceptions, blind spots, maybe even biases. And so that adjudicative function, I think, is really important when it is aimed at the trier of fact, the jury, who's going to be deciding credibility. The harder question is sort of outside the courtroom, what, if any, function do we think experts ought to serve? High profile trials tend to reverberate outside the courtroom.
Absolutely.
And the testimony of expert witnesses can also seep outside the walls of the courtroom then. If you hear, for instance, in the case of Harvey Weinstein, there were experts who testified for the prosecution who talked about the effects of trauma and the ways in which survivors might maintain contact, even if it looks like it's friendly or flirty or intimate. And I think that was really helpful. I think that there was some greater cultural awareness of the real dynamics of abuse that came out of that trial and others like it. I think that having survivors in their own words explain why they did what they did ought to also be compelling and ought to also move the needle when it comes to how people understand this. And so I guess I would like to think that the two can work together and can reinforce one another. The risk is obviously that there becomes a need for the kind of expert to explain what over time should need no explanation, right? We should get to the point where we have sort of cultural understanding that obviates the need for an expert to come in and mediate between the survivor's account and then our own collective willingness to accept it. So I think of this maybe as a problem of transition, and it just happens to be that it's a long period of transition and that it's not kind of moving as quickly as we might like to the next phase of our evolution.
But I do think, and you've written about this extensively, there is this cumulative effect of the multiple testimony, which also has troubling aspects, like how many people does it make do you need to believe, and I've been very kind of confused about, I'm wondering if you have any thoughts on kind of this. It seems like that was a big part in the appeals for Cosby and other people, although that wasn't ultimately the issue. I think in Cosby it was like how many former victims are going to be allowed to testify. Where do you think we are with that?
There's a real disconnect between the ways in which outside of the courtroom we tend to set a threshold for belief. And so we saw in the explosion of Me Too that it wasn't just one woman who would come forward and say this happened. It wasn't even two or three, right? It would often be dozens before something would happen and that threshold for belief would be finally surmounted. And so there was this sense that credibility was gained only in numbers. And without those kinds of numbers, a lone victim or the first victim didn't stand a chance of being believed or having people think it was important enough to do something about this abuse. That's a really different regime from what we have in the courtroom and the rules of evidence that generally apply, which say for the most part, when you're being prosecuted for an incident involving, let's say, sexual assault, the prosecutor is going to have a hard time bringing in other witnesses. They're called bad acts witnesses, right? People who have something to say about a crime that's not the crime charged. It just happens to be really similar to it. And so there's this real toggling back and forth in the law between recognizing that you might want to allow more than one witness to testify in a case like this where it's so hard to get a conviction. And then that general rule which says people only stand trial they only, for the crime that they're charged with, and other witnesses shouldn't be a part of it. And so this has been a real struggle to kind of reconcile that need for many witnesses with the law's kind of insistence that it's only the victim of the charged crime. My thinking on this is that generally speaking, it's a problem culturally that we require so many victims to come forward. That's what needs to change. And one person who comes forward and says this happened, right? That's evidence. That's right. That's something that ought to be taken seriously. That's not to say that that alone proves guilt beyond a reasonable doubt in every case. It's not to say that every allegation of abuse, is true, but it is to say that we are generally speaking bringing too much skepticism to the evaluation of a single allegation of abuse, that we are defaulting to doubt as a society in ways that are unjust.
Of course, in the Christine Blasey Ford case, it can be sort of like, okay, we believe you, but then who cares, right? So, then we get to the next part of the credibility complex, right? Yeah. So it just, it's so frustrating. Well, I have so many things I want to ask you. I know that you've had a lot of hands-on experience with the Model Penal Code revisions, and it seems like just, as a non-lawyer who doesn't, I started in this business in employment discrimination, not criminal law. It seems like we've had kind of at least two sets of obstacles. With the one is the kind of, the classic devaluing of women along the lines that the California legislature said, if you can't rape your wife, who can you rape? And like these sort of, really Neanderthal ideas that persist among a lot of people, mostly men, not exclusively older men, and that our previous guest, Laura Dunn, talked about a little bit. And then we also have this thing which has troubled me quite a bit, the feminists who want to brand any feminist who wants to use criminal law remedies to hold perpetrators accountable as a carceral feminist. So I'd love to hear your thoughts as somebody on the inside, in the room where it happens there. What are you thinking about this process now and the current results?
Yeah, it was a very long and difficult process, and many years spent on this revision of the code. A lot of the disagreement centered around the definition of sexual consent, and for many of us, the sort of modern definition of consent that is consistent with contemporary understandings of sexual relations would require an affirmative consent definition, meaning that someone would have to indicate in some way a willingness to engage in the behavior at issue in order for that to constitute consent. So the clearest way that I can kind of frame this debate is to say, what is the legal meaning of passivity? What is it that ought to be interpreted from someone's silence, utter passivity, doing nothing? And for those who are proponents of affirmative consent definitions, we would say passivity and silence, doing nothing, does not equate with consent, right? You shouldn't have to fight back. Even if the fighting back is verbal resistance, we should be done with the days where we put that burden on victims. We were not able to have that kind of affirmative consent definition adopted in this process of revising the Model Penal Code. There was sort of we could call it a compromise definition that is perhaps more modernized than some, but still allows consent to be inferred from inaction. So that was a place where I think you saw a lot of the difficulty in kind of coming to consensus around what this ought to look like going forward. On the kind of carceral feminist side of your question, there was widespread agreement, I think, among many people involved in this effort that the carceral footprint of our system should be ratcheted down, right? That prison sentences across the board are too long, but that the definition of rape or sexual consent and these sex crimes are not what is responsible for sort of feeding the prison population, and that that project of scaling back the carceral state shouldn't necessarily happen at the initial stage when we're talking about defining sex crimes, that there's something that feels off about that. Now, I will say that many survivors are not interested in having their perpetrator incarcerated.
Right, and that's the thing that's so misleading about so much of promising young women and all of these other kinds of things is that if you actually ask survivors, they have different views, but they rarely involve excessive jail time.
Yeah, and I think there's just some really strong, compelling evidence, Judith Herman's study most recently, that suggests that the power of a criminal conviction, and this was certainly animating my participation in the ALI conversation, is not in the amount of
Right.
Time that someone spends incarcerated.
It's the status you talk about, which is so powerful. Yeah.
The writing, RIGHTING, of a wrongful status equilibrium. That when someone is sexually violated, that is in large part a reflection of the perpetrator's greater power over the victim and leveraging that greater power and reinforcing that power disparity. And when the community comes in and condemns the behavior in the form of a criminal conviction, that can be hugely empowering to a survivor. It can make the survivor understand that the community actually is on her side and not his. And that can do a lot to disrupt those power dynamics that are so harmful. It goes to the betrayal trauma that you talked about earlier. When the opposite happens, when the community does not side with the survivor, that can be as bad as or worse than the abuse itself. Because then it's not just about what the perpetrator did. It's about the fact that the collective essentially is siding with him.
I think that's what many of us interpreted the confirmation of Kavanaugh to mean. That's why it was so crushing. But it seems like this sort of anti-carceral feminism, though, has really seeped into the Title IX discussion as well, to be skeptical about the preponderance of the evidence standard, to be overly concerned with ratcheting up the sort of legalization of proceedings and that kind of stuff. So how do you make sense of that? And because you were on both committees, right? The campus one as well as the criminal law one. And so was there more disagreement on in that realm, or?
No, I think the campus process was an easier process. It took a whole lot less time. That was focused on procedures. And so I think and I should say on sort of general principles that could help colleges and universities kind of distill a set of procedures for resolving these complaints fairly. And so there was a lot more ability to come together and sort of agree on these neutral principles that could guide college administrators. It's much harder when you're talking about, I think the stakes of the criminal law are obviously more severe, more serious. And the substantive definitions that we're talking about raise these very deep questions about, what should we hold people accountable for criminally? and what is acceptable, right? What kinds of things are we going to say cross a line? This line drawing exercise in criminal law is exceedingly difficult, particularly when you're talking about sex crimes, which raise these deeper questions about, sexual entitlement.
I was so hopeful about the Title IX process. When it started, we had tried to do some of the similar stuff and failed at the University of Minnesota in the 90s. And then I thought, oh, this is a great opportunity because, many survivors don't want their fellow student to go to prison, but they would like an apology, or they'd like the person removed from the class, or they'd like the person out of the dorm, or they'd like that validation. Or as one Tulane student said at the town meeting, it like breaks my heart that he's going to walk across a graduation stage on the same day as me, Yet people kind of tend to talk about it. It's like all these concerns about the criminal law have really sort of seeped into these Title IX things, and I think really at most places rendered them unworkable. I don't know if I'm overly pessimistic based on one institution.
Yeah. I mean, the framework ought to be really different, right? In the Title IX context, what we're talking about is equal educational opportunity. We're talking about equality norms, and we're talking about access to educational opportunities, rather than the sort of punitive criminal law. So I think you're right that it would be helpful to sort of start from first principles and then reason through to the kind of processes that we would want in each of those distinct systems. But ultimately, and I'm going to sort of, I think, say what I said at the very beginning, which is that problems of credibility, are the are the
Permeate
thread,
both. Yes.
the
Yeah.
thread that connects these systems, right? And their
Yes.
limitations. And if we think of credibility in an expansive way as it happened, a claim that it happened, but also that it was wrong and it matters, right? So it happened, the perpetrator's to blame, and it matters. And when you think about credibility in those terms, you can see that a credibility complex that cuts across these various systems is going to make them skewed against an accuser, regardless of what the standard is and regardless of what the underlying normative objective is of the system. That's the kind of connecting thread. That's the connecting tissue, really.
Right, and that's one of the things that you point out. The informal means, upping the numbers and making them more believable. Although, of course, I don't know what there's no requirement to do a climate survey, so I don't know what percentage of schools now are doing those climate surveys. I would be surprised if, to the extent that most of them continue doing them, so that they're. When we did the first one at Tulane, first they said, well, we don't have sexual violence on Tulane because we have weaker sororities and fraternities because they rush during the spring and they don't live in the sorority houses, and they don't have a very strong football team, so they don't have a strong athletics, so therefore they wouldn't have all the problems. And then of course they do the climate survey and have like the highest number ever registered, which is not a surprise to anybody who understands the party culture and what's going on campuses and all of that sort of stuff. So there's always these explanations about why it doesn't happen here and why it's just, someplace else. But I become more skeptical about whether we can actually make the Title IX stuff works. But I like that framework, which kind of goes back to the first question we have, is like, how do we really hack away at those components of the credibility complex? And I think having more people come forward and talk about their experience can't be anything other than a good thing, even if sometimes hard for them. Let's see. One of the things I wanted to ask you too is that what you've written about and sort of mentioned, I was looking up the results of the defamation suits about people who are using informal methods, and the defamation suits have also been used as a threat against people bringing complaints on campus. Where do you think we are with respect to that? And do you think that has really chilled people from making informal complaints or formal complaints?
I think that the weaponization of defamation law is a real force to be reckoned with. These kinds of lawsuits have become more common in recent years. There's now kind of a playbook that can be used, particularly outside of the confines of formal processes, where it's somewhat more difficult to be successful in bringing these kinds of claims. But I want to stress that truth is a defense to a defamation suit, and yet the ordeal of being sued
It's just terrifying.
is terrifying. The financial cost, the psychic toll that it exacts. And so I think people are starting to take account of this and maybe think twice about sort of an informal allegation that's public in nature. And I have to say, I think that's very reasonable. I think it's something that should be considered because it is a risk. And even in the end, even if you can prevail and show that this really happened, you are putting yourself in real jeopardy when you go to the court of public opinion and you make these allegations.
Yeah, it worries me too. So you talked about this, we were talking about this internalized credibility discount. So survivors doubt and blame themselves. The nature of traumatic memory is such that it is often compartmentalized. And you talk about something philosophers have labeled hermeneutic injustice, which is better known as gaslighting, which just shows the hegemony of the law to structure the narratives that we use to make sense of our own experiences. And it seems to me whether they're victims of fathers or Boy Scouts or priests or high school English teachers or intimate partners, it takes survivors a really long time to understand what happened and come to terms with their experience and to maybe mobilize to do something about it. So why is it, and is this something that surfaced at all in the Model Penal Code? Why has it been so hard to change the civil and criminal statutes of limitations requirements? And do you have any advice for those of us in Iowa who are trying to get rid of one of the worst state laws for statutes of limitations?
Well, the trend has been in the direction of relaxing or eliminating altogether statutes of limitations for particularly serious sex crimes. I mean, that's happening on the criminal side, that's happening on the civil side. There's been the Adult Survivors Act in New York State. There's a similar statute in California that has kind of opened up a look back window for civil claims. And I think this is happening because there's greater recognition of how difficult it is to come forward for the reason that you just described very movingly, this sort of making sense of your own experience and being able to label it, much less be able to talk about it. That is so, so difficult. And then you're up against this credibility complex, which gives yet another disincentive to coming forward. So I think that these obstacles they came into focus more in the last 10 years or so. I think that that's part of what happened with the Me Too explosion, was that it became easier to see some of these barriers. And I think that then fueled kind of a next wave of reform around these statutes of limitations. So at the end of the day, particularly in criminal court, the burden of proof remains very, very high. And some older cases are not going to be provable anymore.
That's the thing. It's so hard to prove them anyway, but you have, the Catholic Church and insurance companies lobbying heavily against them, and, they're very difficult to change.
Yes, they are. But I think for those states that have gone ahead and made some changes, I think that there is an understanding that we are hopefully becoming more adept at fairly judging these kinds of claims, and that we want to give survivors the opportunity for their stories to be heard in court when there's a chance that the case can be proven, either criminally or civilly, and that accountability matters, and that justice and accountability don't have an expiration date.
One of the things I especially appreciated that I've just sort of connected now listening to you talk is about in your victim piece and talking about expert testimony that doesn't pathologize women's behavior. You know, we have in political science, they talk about why women don't run as the gender gap in political ambition, as if, you know, political ambition is something that you have when you come out of the womb, and it's not constituted by thousands of daily interactions with people who say you should be president to men and not women or whatever. And then, you know, this whole thing about imposter syndrome, you know, it's like, again, it's, or you know, women don't ask for, you know, raises or whatever. But what I love the term credibility complex because it doesn't have that pathologizing piece. And I think it's actually, you know, so much more helpful than, you know, the terms rape myths or rape culture, because it's always really troubled me, that term rape myth, because it suggests, you know, like, oh, if we just know that 90% are known, you know, then, oh, we'll say, oh, silly me, I had this false idea and it'll go away. But, you know, the credibility complex, it seems like it explains the tenacity of the problem much better than any of those other terms.
Thank you. I mean, I was really committed in the course of writing this book, but in other research as well, to shifting from an individual perspective on the problem and taking a more structural perspective and sort of looking at context, looking at the collective, and I sort of try to do a structural analysis of credibility because I think that that is more helpful, and ultimately those are the kinds of fundamental changes that we're going to have to make if we want to see progress, if we want to see real inroads.
Right, because there's this kind of some writing in the, you know, in the literature, like, if, you know, if it just hadn't been for Lord Hale, we wouldn't doubt women, you know. And it's like, you know, no, he's really capturing as well as reinforcing this idea. It's like just not one bad mistake. Well, I guess the last question I have for you is, you talked about how these informal channels are really functioning as a form of consciousness raising, which you define as interactive and collaborative process of articulating one's experiences and making meaning of them with others who also articulate their experiences. But as you note, only a small portion of those informal channels have the effects of actually holding abusers accountable or changing norms. And I was really struck by the section in your piece about how the senior women in the law firm warning the younger women. It's really a message, you know, that keep yourself safe, but just rest assured that this is a part of law practice, and even those of us who are powerful can't do anything to stop it, and we won't even try. So keep yourself as safe as you can. So how do you think we should go about trying to mobilize this kind of awakened, really large group, which I think now has the benefit of including a lot of male survivors with the Boy Scouts and the priests, to just not just complete the rape law reform agenda, but to actually make some systems of accountability work? Any thoughts on that?
Well, it is of course a big question, but I guess my aim with the informal networks pieces is to kind of sketch out the virtues of informal reporting, which I think are many, and to put them in the context of system failure, but also to underscore that these solutions are incomplete, they are partial, and ultimately kind of, I think, a stopgap, right? We may never reach the point where for every survivor, a turn to formal mechanisms of accountability is the right choice. But I think we're far from the day when we can say that these are meaningful choices that people are making. They're not. So I would like to see work on all of these different system levels, and I will, stress again that I think that survivors should have options. I think that survivors who choose restorative justice processes, there should be more of those, and they should be skillfully managed, and they should be in the hands of people who understand structural power imbalances. I think that civil justice ought to be more of a possibility. I think that abusive discovery is something that needs to be addressed. I think that non-disclosure agreements
Yes.
need to be addressed. On the criminal side, there's a lot of work to do. These doctrines continue to be archaic in many places, and law reform is important. But maybe I guess we can end where we started, which is to say that the work that we can all do is on this question of credibility and on transforming the cultural side of things, so that when a survivor comes forward, and maybe it's to a family member and maybe it's to a roommate, but that person responds in a way that's fair and that doesn't do the disbelieving, the blame shifting, the disregarding, right? That we kind of just flip our responses as individuals, which gets us to the structural, because of course these structures are all of us.
Well, thank you so much for giving us this fabulous vocabulary and evidence and theory to back up these arguments, and for all the hard work you do on the Model Penal Code. And I can't wait to see what you do next.
Thank you so much. I really appreciate the conversation, and of course your work as well.
Okay, thanks, Deborah. Bye. I owe a debt of gratitude to many who contributed to the second half of season 2 now that I have moved home to Iowa. Music credit goes to the talented Jerry Lee Kenny on saxophone and to the late Dwight Champagne for his original composition, Surrender. Thanks to all my new friends and colleagues at Amplified in Des Moines, Amner Martinez, Laura Rodriguez, Aki Petavine for production and edging me into video. I would also like to thank the many students in my classes on rape and gender-based violence over the years for all I have learned from them, my rape pen pals, and my newfound community of those working to end sexual violence in Iowa, in particular through the Iowa Coalition Against Sexual Assault. Lastly, I'd like to thank the many survivors, not just scholars, who disclosed to me as students over the last 37 years, especially those in the Louisiana Correctional Institute for Women, 13 of whom just received their undergraduate degrees from Tulane University in October, and the Homestead Correctional Institute for Women. Your courage, humor, resilience, and determination to find joy showed me the way.